One of the most audacious, flagrantly unconstitutional things Donald Trump has done, he did on the first day of his second term, day one. He signed an executive order decreeing an end to birthright citizenship, an effort to begin denying citizenship to babies born here on U.S. soil. Today, the Supreme Court heard a challenge to that order, with Trump right there in the gallery, the first sitting president to ever attend the court's oral arguments. But he left shortly after his Solicitor General defended his order to end birthright citizenship, perhaps because it was already clear that most of the court's conservative justices are very skeptical of the government's case.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
You say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual.
And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
Sherrilyn Ifill is a professor of civil rights at Howard University. She's also founding director of Howard's 14th Amendment Center for Law and Democracy. She was previously the president and director counsel for the NAACP Legal Defense Fund, and she was at the Supreme Court for oral arguments today, and she joins me now. Sherrilyn, it's great to have you as a constitutional scholar and practitioner at the 14th Amendment Institute, which is, of course, where this right is grounded textually. First, just tell me what it was like in that room today.
Well, it was, Chris, thanks for having me. It was a packed courtroom, of course. As you can imagine, lots of interest, lots of different folks who normally would not be in the Supreme Court gallery were there. Robert De Niro, for example, and also, of course, President Trump at some point. It was actually very riveting argument. You could feel everyone paying attention. The justices were paying attention. They were quite well behaved and certainly not in any way sniping at each other or at counsel. And so everyone was listening very intently to this argument. You know, I have to say I was personally quite satisfied with what I heard.
Yeah, I mean, one of the things that's strange here is, before we get into it, usually an argument this clear-cut doesn't get to the Supreme Court. I mean, people may not know this, but the court only takes the cases it wants to. It's a tiny, infinitesimal little sliver of the amount of people that petition the court. And almost in all cases, they're taking it because there's some real ambiguity. There's maybe different lower courts found differently on this question. Here you've got the text of the 14th Amendment, which says all persons born. And then you've got a 150-year-old precedent back in the 19th century when they decided this. And not much else other than the fact Donald Trump wants to get rid of it.
Well, you know, Chris, I've been thinking about that, and I think there may be something else. You remember the posture in which this first came to the Supreme Court. It was in the posture of a district court having issued a nationwide injunction, something that has been on the list of things that the conservative justices wanted to deal with. And they were able to do that in Trump versus Casa. They were able to bind district courts from issuing these nationwide injunctions. So it was worth it, I think, for them to take the case in that posture. And then having taken it, you know, they had to make the whole thing look good by, you know, suggesting that it was a real case. Because I think most of the people sitting in that room today, and certainly anyone who has studied the 14th Amendment even cursorily, knows this case should never have been heard by the Supreme Court. And it left Solicitor General Sauer up there today trying to piece together an argument out of some remnants that, frankly, you know, were largely made up and that are not grounded in the text, the history, the origins of the 14th Amendment, or of the most significant cases to have looked at birthright citizenship since the amendment was ratified in 1868.
Yeah, I want to play this moment because I thought this was kind of a very funny moment. Cecilia Wong, who's the ACLU attorney who argued this case today, and I thought did a very good job. The controlling precedent here is that the actual court heard this very question pretty soon after the 14th Amendment was ratified. It's the same court, we should note, that issued Plessy, okay? So not like the most progressive court in the world. A man named Wong Kim Ark. And here's Kavanaugh basically saying, well, if we don't overturn that, is our job done here? Take a listen.
If we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondents' reading. Government doesn't ask us to overrule. Affirmed.
Yes.
That's that.
I thought it was such a funny moment because, like, yeah, right. Like, we can just affirm the thing that's been extant for 160 plus years.
Yeah, you could, but it also leaves, the position Kavanaugh was trying to carve out, I think, which is that, the belief that potentially Congress has some play here, that Congress could actually restrict birthright citizenship. When in fact, as was stated in the argument and by Cecilia Wang, the lawyer for the ACLU, who argued the case masterfully, I might add, the point of the birthright citizenship clause was absolutely to ensure that successive Congresses could not actually change or diminish birthright citizenship and create a caste system of citizenship, which is, of course, how we ended up at the Civil War after the Dred Scott decision. So, but Kavanaugh seemed kind of enamored of the idea that Congress might have some power or some play here. And I know there are those who say, well, our Congress is hopelessly deadlocked. But, always count on Kavanaugh for the kind of political reading that somehow might unhandcuff a Republican majority. And so I think part of why he was saying, can we keep it really brief and really thin, was in some ways to leave that pathway open. Yeah. Yeah.
So I mean, this brings me to sort of the stakes here, right? Because it's more than, there's a textual argument and a historical argument. There's jurisprudence, but fundamentally that, like, the principle enshrined here is actually at the core of what it means to be American, to think about why America is a great place, honestly, what makes us special, is this idea that every citizen, everyone born here is equal to every other person. We don't have second-class citizenship. There's no nebulous second category where you can kind of hang out, but you don't get all the privileges and immunities. And, like, taking that away would mean something utterly profound and transformational to what it is, this country that we love.
I couldn't agree more, Chris. I've been saying that this case is not only about democracy, it's not only about citizenship, it is about our national identity. The very idea of America, and America is an idea as much as it is a place, is that it is, this place where people get to start over. Those who came from Europe, the so-called old countries, felt that they were constrained by, who their parents were and what class system they fell into. The point of coming to America is that, as my dear friend Martha Jones, the historian, says, that individuals are not burdened by the limitations and the disabilities of their parents. And so even if you came to, let's say Ellis Island, and the baby was born the next day, it didn't matter who their parents were, what the class of their parents were, they were a citizen. And of course, for black people, like I heard them keep saying that, this is about newly freed slaves and their children. It was about black people, because the Dred Scott decision had said that black people were not only not citizens, but could not be citizens. And so it swept in not only enslaved people, but also black people who were free. And so it's important to understand that scope of what they were trying to correct. And of course, as you know, Chris, in the legislative history, there were explicit conversations that raised many of the same kind of invasion ideas that we hear now about immigration from Latin America that were being raised about the Chinese. There were members of Congress saying we're going to be overrun in California by this group that cannot assimilate, that is not part of us, that doesn't share our values. And those voices were overcome by the other voices in Congress who said, but the children of those individuals, the American-born children, will be citizens. And that was the context in which the 14th Amendment was ratified.
All right, Cheryl and Eiffel, what a treat to get to have you today. Thank you so much for joining us.
Thank you. Thank you.